Show where it's you and the law, where you'll have an opportunity to call in and get some free legal advice from two attorneys. But first, it's time for our happy attorney story, where you and the attorney make some money and live happily ever after. I had one client who came in 30 days before his trial was set. His last two attorneys had dropped him. He didn't know what to do. What had happened was he rented a piece of property. He fell into a large hole on the piece of property he rented, perhaps twice as big as this studio. Obviously, why he didn't see the hole, we'll never know. The fact is there was bad liability. Whose fault is it that he would walk on and fall into a giant hole? So the attorneys for him sued the insurance company of the property he rented. Unfortunately, they didn't want to pay anything. He had $50,000 worth of medical bills. He comes to me and says, what do I do? The two attorneys have dropped me. The insurance company doesn't want to give any money. I've got all these bill collectors coming at me. So I looked at it, I smiled. I called up defense counsel. My first question was, is there any nuisance value? They started out offering me $5,000. I got it up to $35,000. Of course, I had to take my third. I then called all the doctors, got them to take 5 cents on the dollar. They were all paid off. They wouldn't go after him. My client took a third, and he was happy to have some money in his hand. And once again, the client and I lived happily ever after. With that happy attorney story, I want to introduce to you one of the excellent attorneys in our valley, Avrum Harris. Avrum, welcome to the show. Avrum, I've seen him in trial. He's a great attorney, and I really mean great. He's the alternate public defense counsel. He represents indigents, people who need representation. But he looks at, I think, every case as if it's the most important case he's ever had and gives it his all. Avrum, I have to really admire the way you represent people.
Thank you.
Now, how does someone qualify for your services for the alternate defense counsel? When does it kick in?
The Office of the Public Defender has the duty to qualify people at the scale. The Board of Supervisors has set it up so that the Public Defender's Office has the people fill out a financial form indicating what their assets are, what their liabilities are, and they have a cutoff depending on the nature of the crime and their idea of how much it would cost to retain private counsel, whether the person could afford it.
Now, you do criminal. What are some of the interesting cases? Just give us perhaps an example of one you've seen. I know you've done thousands.
I hate to answer a question with a question, but what do you mean by an interesting case? Some of the most interesting would not be appropriate fare for television.
Okay, I would say something that was interesting to you, but would qualify for being on TV.
I had one case, one of the homicides that I had, wherein the only portions of the anatomy that were recovered were the head and the feet. And what the police had to go through to determine who the decedent was and the nature of their investigation made it one of the most interesting cases that I had had. Obviously, with no hands, there were no fingerprints. There could have been dental records, but they didn't know where to check them. What they did was they put out what looked like a wanted poster based upon an artist's rendering of the head and said, "Do you know this person?" Surprisingly, there were just tens and tens of people who called up attempting to identify the person. One of them turned out to be right, and the investigation went on from there.
What happened to the parts in between?
When the body was dismembered, the head and the feet were placed in one trash bag and tossed into the Angeles forest. The rest of the torso was placed in two different bags and gotten rid of the same way. They were never able to recover the rest. Interestingly, local deputy by the name of, the way it was discovered was a local deputy by the name of Steve Haberson was on a stakeout in the Angeles forest. He and several local deputies and the DEA and a couple other law enforcement agencies were staking out a marijuana plantation. They heard a car come up, saw a trash bag go over the side, and they thought that it was things for the growers. So they waited till the car left. He shimmied down the side of the mountain on his belly, poked a hole in the bag, shined in a flashlight, and as he says, there was an eyeball staring back at me.
That's pretty scary. Did they ever find the, obviously went to court, they must have found the individuals who allegedly committed the crime.
He was convicted. He's now guilty.
Did you represent anybody in that case?
Yes.
Did you represent one of the alleged perpetrators?
Yes.
And was there any defenses at all in that?
Yes. Obviously, it didn't prevail. He was found to be guilty. He is now serving life without parole.
And probably well deserved, I might add, in my, that type of crime. But that's my own personal opinions. But do you get a lot of those type of serious felonies that you have to represent?
I only handle felonies. And by their very nature, what makes a felony is that the presumed sentence is state prison.
A year or more.
16 months or more. Sorry.
No, it's okay. I always thought a felony was a year plus and misdemeanors were a year under.
No. Crimes are classified by possible penalty. If the only penalty is money, it's an infraction. If the penalty can be money, community service, or up to a year in county jail, it's a misdemeanor. If the prescribed penalty is county jail, state prison, the lowest term of which is 16 months, 2 years, or 3 years, then it's a felony. Based upon the person's background, the judge has the right, or the district attorney on the plea bargain has the right, based upon the totality of the circumstances, the facts, the nature of their involvement, and their prior history, to put the person on probation and give them up to a year in county jail. If after they've served their time in county jail during the probationary period, they violate the law or mess up, even if it's not a violation of the law, if they don't contact their probation officer or test dirty for drugs, anything of that nature, then they can go to state prison.
What percentage of your cases do you win? Do you have any idea?
Again, it depends what one conceives of as a win.
Well, not a plea bargain, but it actually goes to trial.
Well, the percentage of my cases that goes to trial is lower than the state average. The percentage of cases that go to trial is 5%, which probably surprises most of the general public who watch television, wherein every case goes to trial.
Well, what I've noticed is the ones that go to trial are either, in my opinion, either the very guilty who have nothing to lose, say a 3-strike, or the very innocent, they're going to fight no matter what. And those that might be guilty and want to get a penalty or something, kind of plea bargain in between. What's your experience?
I'd say that's appropriate. If the people have an incredibly good case, it's probably going to go to trial. Somebody once said to me, and it's proven to be correct, the good cases don't go to trial. That means when it's good for you, the people are going to settle.
Do you ever advise an innocent person to settle?
I don't advise anyone to settle. I look at it that a criminal defense lawyer has 3 duties: to fight for the person as hard as he can or she can at any evidentiary hearing, discovery motions, motions to suppress, preliminary hearing, trial, things of that nature. The second, according to the Supreme Court, is to get the person the best plea bargain offer you can. The people do not have to offer a plea bargain, but it's our job to get the best offer we can. And I think our third duty is to explain both the law and the facts and how the procedure works to the client so that the client can make his own decision. I'm not going to do a single day in custody, so I would not presume to advise someone whether or not they should take time in jail. If I'm wrong, I wave at the bus and that's it. I'm not going to pay their fine. I'm not going to do their community service. I'm not going to do a day in jail. It's not my life. It's not my decision. It is, however, my responsibility to see to it that they can make an informed and knowing decision. They don't always make the decision that I would make, but it's their life.
How do you, and forgive me for deviating, how do you feel when you have an innocent client, let's say they get convicted? Has that ever happened?
I presume it's happened, but I've been practicing law for approximately 23 years. And it's taken a great deal of time to learn not to be concerned with innocence or guilt. That's not my job. Innocence and guilt is the purview of the judge or jury. Innocence or guilt is the purview of the district attorney's office. My job is not the flip side of the DA's job. My job is to fight for my client as hard as I can, whether or not the client is guilty. We, according to the system and the way it's set up, we don't have to prove anything. The question is not, is the client guilty or is he innocent? And you can thank television for mixing this all up, but the concept is the client guilty or is he not? Hence the choice of possible verdicts for the jury. A jury cannot bring in a verdict of innocent. And innocent and guilty and not guilty Innocent and not guilty are not synonymous.
So guilty obviously is a burden beyond a reasonable doubt, and innocent is a whole other picture. You're just
Right.
trying to, can we meet that burden or not?
Not guilty means that the prosecution did not meet their burden. As I've explained to some classes I teach, and basically to anyone who will listen, the question is not the ultimate truth. The question is, can the government prove that you have done something wrong to the point where the government has the right to punish you?
Do you ever get creative in your plea bargains? Let's say someone has used drugs, and instead of jail, you suggest they go from school to school and perhaps give a program. Do you ever come up with creative ideas, or is it usually how much time is the main negotiation?
It's usually how much time is going to be involved in custody. The DA's office, for the most part, on felonies, is not interested in creative situations. There was a time when the purpose of the system and the goal of the system was both rehabilitation and retribution. Now the goal of the system is simply retribution. It's punishment. And
It's to protect the society.
yes, I like to say that the purpose of the DA's office and the police department is to protect society. The purpose of defense lawyers is to protect the freedom of society. Not necessarily the individual, but of society. It's by protecting the rights of the individual that all of us retain those rights.
I like what Justice Learned Hand said. He said, "My rights end at the end of my fist and the beginning of your nose," which meant to me that we have limited rights. We have rights until they start infringing on somebody else.
I'd agree with that. And for the most part, unfortunately, society is willing to give up their rights and exchange that for security, or for their concept of security. That's why people have difficulty with search and seizure issues. A number of people over the years have constantly asked me, if somebody doesn't have the right to hide, why not let the police inside your house to search? And my response is, why do I have to prove that I have nothing to hide? I would question how many people in our audience out there today would just allow the police to knock on their door and go through their house and go through their belongings so that they could prove they had nothing to hide.
You know, and I would say how terrible I think that is. I represent juveniles too, and usually they check on there that the juvenile, when they're on probation, have to submit to search and seizure at any time without a warrantless search, even in their residence and in their house. And I had the unfortunate of going to a house by accident and seeing the four sheriffs show up with guns to search some poor 16-year-old's room.
But you preface that by saying that the juvenile, was on probation. He was on probation instead of being incarcerated, and one of the privileges that the juvenile gave up, or adults give up for the purpose of being on probation, is they give up the right to be secure.
Let me
and
go-
they are
Go ahead.
told that they have to, as a condition of probation, submit to search and seizure any time of the day or night, with or without a warrant. And if they don't agree to it, then they spend longer in custody. Or if they're out on probation and the circumstances arise and they refuse to submit, they can be restrained by force. The search can take place anyway, and the refusal to submit is a violation of probation, and they can get additional time in county jail or in state prison.
Let me go one step further. I had one minor where the cops showed up at the house. There was a party. The cops came into the house despite the minor saying, "Don't come in." The police felt they had probable cause, but did a warrantless search.
Was he on probation?
And this one was not on probation. The point of it is, I looked up the law myself, representing the individual, and on that type of a situation, they need what's called exigent circumstances in order to do it, and the probable cause is not enough
Right.
just to come in. But unfortunately, we're set with a situation where the police, who I have a great deal of respect for, if they break the rules, you know, we're still stuck with the damage on how to overturn it. And I seem to see that more often than not.
But for the most part, the public likes this. They might not like the results in that particular case, and the one who's going to be most upset are the juvenile's parents, or the parents of the other juveniles who were there, and it's only because they are at that point in time having immediate first-hand contact with an abuse of the law. But when they see it on television, when they see the tough guy cop on television go to the door and threaten the bad guy with something that is an obvious violation of the law, such that the bad guy caves in and the dope is found, or the bad guy caves in after being threatened with the planting of evidence, they all sit there and applaud. Because, gee, justice is finally being done and the bad guy is being carted away. But when it's their child, their house, their property, then they're all bent out of shape. I see it every day when middle-class families, I'm representing the husband, the wife, the daughter, the son, the first question out of their mouth is, how can they do that?
I think the abuse of rights of one is the abuse of all.
Without a doubt.
And I think one example, and we'll get back to the regular stuff, but the Skokie, Illinois case, where a group of Nazis wanted to parade in front of some Jewish immigrants, and the ACLU, which lost half its membership over this case, decided to represent the Nazis. And I think we have to protect rights, but part of that protection is people have rights, but they don't have the right to abuse other people's rights or the extermination of another group.
Okay.
So I think there is a balancing act, so to speak.
There's constantly a balancing act, and that's what the law is based on. Unfortunately, the more fearful people become, the more willing they are to give up their rights. I mean, it's like the expression in Italy under Mussolini, the trains ran on time. They never ran so well before or after. But in order to have the trains run on time, people gave up all of their rights to a fascist government. And rights once taken are very difficult to regain.
Let's go back to that search and seizure. When someone is stopped by a cop or a policeman or a sheriff, how much of a search can that sheriff do in that car? Now, I've seen where the sheriffs have pulled the seat out and gone through the car.
Well, there's an interesting case that made it all the way to the United States Supreme Court, and the case came out of Texas. And it is setting precedent for the rest of the country. The case held that even though let me back it up. Most moving violations are misdemeanors, meaning that technically you could go to jail over it, which also means that the police officer does not have to let you go based upon your promise to appear, and that's all you're doing when you sign the bottom of the ticket, saying, I promise to appear. They do have the right to take you to jail and make you post bail or wait until arraignment takes place, and then the judge might or might not release you on the lowest form of bail, which is your promise, OR. You're being released on your own recognizance, the promise to come back. And since the officer has the right to detain you, or more than detain you, has the right to take you into custody, if he takes you into custody, the car can be impounded. You're given storage costs on a daily basis. When the car is taken into custody, they have a right to do an impound search, which means for their protection, so you later...
Inventory search.
Right.
But they can't, but if you have a small box in that car, don't you have an expectation of privacy? In that box, or can they go through every little thing if they impound that car?
If they're going to let you go, they can't go through every little thing. However, if an impound search is being done, clearly those who are going to have custody of the vehicle don't want you to come at them later hiring a lawyer to say, I had the crown jewels in this box in the trunk and the box is now missing. So they then have the right to go through everything in the car and inventory.
I thought they could only, if they suspect, first they'd have to have probable cause. They could only search within your area of where you could hide something or get a weapon.
We're talking apples and oranges. You're talking about where can they look in the car at the point in time when they stop you. I started all the way on the other end. If the car is taken in, everything in the car can be inventoried.
What if they just stop you, they give you a ticket, and they say, can we search the car? And you say no. How much of a search can they do in that car?
At that point in time, if they're going to let you go, they can do nothing. But reality says they don't have to let you go. They can say, okay, you're in contempt. Well, they don't say, okay, you're in contempt of cop, but that's what they mean. We are now not going to release you. We are going to take you into jail. And by using that subterfuge, it is perfectly legal for them to then inventory the car.
If you've signed the ticket to promise to appear in court, and then they want to search the car, and you say no, are they stuck because they've given you the ticket?
No.
Talk about a lack of rights.
Let's talk about reality. That is reality. Unfortunately, most people do not understand, both in a civil case and in a criminal case, people do not understand what their rights are. It's one of the things that got me to law school. I didn't go straight from college to law school. I was in business in between, and I was constantly amazed at what was and was not reality. I went to law school and ended up here. But not only my clients, when I teach law several times during the year, people who are not criminals, who are taking legal aid classes and want to become paralegals, they are constantly amazed at what the state of the law is. And they go, what about my rights? And you go, these are your rights. You were just functioning under a misconception. People are unaware of the fact that their rights are changing daily.
I mean, through the legislature, through interpretation?
Through the legislature, through case law coming down daily. People are totally unaware of it.
What are some of the rights that are changing?
Rights to privacy. There was a law that was enacted several years ago called terrorist threats, 422 of the Penal
I've seen that seems to be in vogue right now here. A lot of the kids who are either allegedly threatening get charged with terrorist threats. I mean, I've seen that come out quite a bit.
You're right. It's in vogue. It was a knee-jerk reaction by the legislature to the family law situations wherein one spouse, generally the husband, was threatening the wife with, I'm going to do this to you, I'm going to do that, you better watch your back. And the wife was going, I'm afraid. So the legislature passed a law that said, in essence, that it has to be imminent danger to someone who you either had a meretricious relationship or a live-in relationship with, and it had to be imminent danger to them or somebody close to them. And the Supreme Court, in its omnipotent wisdom, has determined that imminent doesn't mean immediate. And it can be as far down the future as months or years. And there's more, because it turns out that the standard is not would a reasonable person be afraid in those circumstances. It's was this person afraid. So the jury in those cases doesn't get to determine if the person's fear was reasonable. They only get to determine whether the person was actually afraid.
Avrum, I want to remind the audience that you can call in, ask Alternate Public Defense Counsel Avrum Harris or myself, Steve Fox, a legal question. The number is 726-0382. That's 726-0382. I also want to talk about domestic violence. I walked in one holiday, found 3 women sitting there who'd had altercations with their husband. All 3 of their husbands had been arrested. They wanted them back, and the DA said no. They'd performed a crime against society. Shouldn't the victim have something to say about, hello? Shouldn't the victim have, let me try this other line. Attorney Steve Fox and Attorney Avrum Harris.
Yeah, how's it going, guys? Yeah, the Supreme Court here, they're all having butt sex together, right? I mean, is that legal, or are they going to have some problems with that?
Bye. Sorry.
Sorry, that, oh well, I can, we're attempting, we're still having technical difficulty. Going back to the domestic violence, shouldn't the victim say, I don't want the charges, I want my husband back?
I don't believe so.
What I see a lot when 2 people get in a fight, and one person calls the police or the sheriffs, they arrest the husband, but they've both been involved in the altercation. Why aren't both of them arrested? It seems to be...
I can't answer that question. You'd have to ask a policing agency what their guidelines are, what their rules, etc. But what you bring up is one of the most frequently misconstrued ways that the law works. I constantly hear from my clients or their families that so-and-so, the victim, is going to drop charges, or so-and-so is going, why can't I press charges against somebody? And what the general public doesn't seem to understand is that in the criminal law system, it is not the individual who was injured,
But society.
And in the criminal complaint, the person is being sued no different than in a personal injury case. The plaintiff is the person who was injured. In a criminal case, the plaintiff is the people of the state of California. So since the victim, the person who was injured, did not bring the cause of action, they don't have the right to drop it. They can say, I want charges brought, and the district attorney, the filing agency, can say no. Or they can say, I want charges, I love him, I want him, I need him, who's going to pay my rent? And the district attorney's office can say tough.
Okay, with that, we'll go to a commercial. Again, you can call in at 726-0382. Welcome back to the Steve Fox Show, where it's you and the law. where you have an opportunity to call in and get some quasi-free legal advice. The phone number here is 726-0382. That's 726-0382. You can call in. Tonight we have a very special guest, Avrum Harris.
Thank you.
Who's part of the alternate public defender. And actually, I'd have to rate him the best criminal attorney, the best defense criminal attorney, in my opinion, in the Valley.
Thank you again.
Past that. No, that's my real feelings. I admire the way you practice. And again, you have abilities that far outweigh myself. You had some war stories you were going to tell me.
We were just discussing 422 terrorist threats.
Right.
People don't realize the total amount of the population that is taken. That's a very awkward sentence. Let me just get into the story. I had a client, without getting into names, he was in a home a halfway house for the emotionally disturbed. He had been in and out of this type of residence since he was a child. And he was emotionally disturbed. He had anger management issues. He was on medication. So he's an adult. He's living in a house for the emotionally disturbed. He got into a verbal altercation with the people who managed the facility. He threw his dinner plate and he started throwing a tantrum. I'm going to kill you. You don't cook well. This food isn't fit for animals. I ought to make you eat this slop. I'm going to grind your face into it. They called the police, and he was arrested for terrorist threats. Now, that's a strike. And periodically, because county jail is not set up to deal with people who are under psychotropic mental medications,
Sure.
What they were doing with the entire mental population at that time, to use a slang phrase, is they were giving them Benadryl. They could not give them all of their psychotropic drugs, so they were giving them Benadryl, which
Quiet them down a little bit.
quiet them down, have them sleep. When he would come to court, he'd be out of it. He'd be a space. He'd either be tired or he'd be out of it because his mental processes were off. I mean, this guy was under enough medication to keep a pharmacist happy for life. Finally, I got court orders. I had the guy brought in and given his own medication. He came in and we talked. This is after he was twice sent to Department 95. For them, it's a special department that adjudicates whether or not he's mentally competent.
Sure.
And there he threw a hissy fit such that even though the psychiatrist said he was mentally competent, the judge said to me, I'm going to keep him for a longer evaluation. Instead of the 5-minute evaluation to determine if he's mentally competent, can you stay till the afternoon? I said yes. She says, I'm going to have him seen for the long evaluation. Again, the doctor determines that he's mentally competent. The judge who deals in these types of cases day in and day out is just amazed that this client is found mentally competent. And she says to me, I'm recusing myself. That means she's taking herself off the case. If I want her as a witness in a sanity hearing for this client, she's willing to do it. The district attorney said if I wanted to subpoena her to be a witness that this person was not competent to stand trial, she would do it. And I looked at both of them and said, no, I'm going to take this case to trial. The doctor is certified that he's competent, and the charges are absurd. He is doing what an emotionally disturbed person does, and they want to send him to prison. The offer, because he had prior criminal activities in other facilities for the emotionally disturbed, the offer was something like 2 or 3 years in prison.
So you're saying for people who have mental problems, they're getting more jail time because they don't know how to deal with the system, or what's happening here?
In a lot of cases, they get more jail time. In his circumstance, the day I announced ready for trial, and it was delayed because periodically he would be under the drugs, then he would be competent, then he'd be off the drugs, he'd be incompetent. The day I announced ready for trial, they made him an offer, and the offer was, if you plead guilty, we will let you out of jail today.
So the society gets its pound of flesh, or its statistic, the DA gets to say guilty, and he gets unleashed on the society.
He pled guilty against my advice. I did not join in the plea, and he was released, and he was a probation violation waiting to happen, which is what I believe they were waiting for. The standard of proof at a probation violation is not a reasonable doubt, but beyond a reasonable doubt, but it's a reasonable suspicion. And the minute he doesn't report, the minute he does anything wrong, a petty theft, yelling at somebody else such that a terrorist threat situation is created, they could send him to prison. Sure enough, a year and a half later, I'm amazed he lasted that long. Excuse me, it was 9 months later. he picked up another charge.
I almost look at probation as the spider's web. If you spit on the sidewalk, they grab you back and put you in jail.
That's
I'm
what
almost
it's set up
afraid
for.
to let anybody on probation, even though it sounds good. You do everything right and you're clean in a year, 6 months, whatever the probation is.
There are those times, though, that it's a saving grace for a lot of my clients.
We've got a phone call. Hello?
Yeah.
Yes, this is Attorney Steve Fox and Attorney Avrum Harris.
Yeah, am I on the air?
Yes, you're on the air.
How's it going, guys? I heard you guys talking about, mentally ill people, and I haven't committed a lot of crimes, but I've committed a few. And, oh my God. Oh.
Hello? Again, I'm sorry. Please try to call in 726-0382. Again, we're dealing with criminal law tonight, but you're welcome to answer or call in on any question you'd like. I do both civil and criminal. Actually, I do whatever pays. And Avrum specializes in defending people, far superior than I could do.
Thank you.
And tell me something. When someone comes in and they want you, can they request you, or is it the luck of the draw to get you?
Well, first, they have to qualify for the services of appointed counsel. And the first one up to take the case is the Office of the Public Defender. If the public defender can't take the case for any reason, there's two clients or two defendants charged in the same case, or one of their clients is a witness against this person or something of that nature, then my office sees if we can take it. And then my office has its own procedure on which one of us gets it. I work with some excellent lawyers.
Can somebody request you if they're in that position at that point?
They can request me. That's not going to make a bit of difference.
We were talking about some of your famous war stories, since you've seen thousands of cases.
There was another situation, and I like this war story because it highlights some of the communications problems and skills that a lawyer really needs. I had a client who was a woman, again, her name is irrelevant, and she was charged in two different complaints. One was about 87 billion charges of passing bad checks, and the other charge was residential burglary. And I couldn't quite understand, if she was indigent, how she could be out on bail in these circumstances, and when I met her, I understood. She wasn't emotionally disturbed or mentally disturbed, but let's just say she wasn't the brightest bulb on the tree or penny in the stack. And one of my jobs, as I said, is to explain to somebody what's going on. So I'm standing out in the hall in front of Division 1, and I'm trying to explain to this woman that she is being charged with bad checks. She said, "What makes them bad?" And I said, "Miss So-and-so, the checks bounced." And she looks at me with utter confusion on her face, puts a hand on her hip and springs out the hip and says, "I thought you were a lawyer." I said, "Yes, ma'am, I am." She says, "I thought lawyers were smart." I said, "Some are smarter than others." She says, "Then, sir, you should know checks are made out of paper and they don't bounce." And I'm trying to figure out if she's putting me on or not. And I'm looking at her and she looks very sincere. And I said, "Well, I'm sorry for using that term that you obviously didn't understand. Let me ask you this way. What made you think you could write those checks?" And she looked at me and said, "'Cause I can write. So I wrote the checks." Now I know I have a real problem on my hands. To make a long story short, because that interview lasted about an hour, the situation was she received an advertisement from the bank that said, for the cost of printing your checks and for $5 in the bank, you too can open up a checking account. So she did. And when I asked her, "Mrs. So-and-so, what made you think that there was that kind of money in the bank that you could write those checks?" And I really have to say at this point in time, out of like the 40 or so checks that she wrote, all of them were for food, and it wasn't steaks or anything. It was the basic staples of life. Because we had duplicate receipts. I mean, it was bread and milk and cheese and meat. And I said, "What made you think you could write?" Once we were beyond the fact that she could write, she looked at me and she said, "Mr. Harris, I'm starting to worry about how good you're going to represent me. They're a bank. They have a lot of money. Do you understand that? They gave me the checks. So I used them. I'm not out of the checks yet. Why am I here? I figured, okay, let's move on to the second charge. And the second charge was residential burglary. And here I was going to find out if she was jiving me or not. And the situation was that she and a friend went into somebody's house without permission. Now, a burglary is the entry into someone's place with the intent to commit a theft or a felony inside. So the people's position was that she had entered with the intent to steal, even though when she came out, nothing was taken. You don't have to take for a burglary. That's another misconception. It's your intent at the point of entry. And I asked this woman, why did you go into the house? And she looked at me and said, Mrs. So-and-so, the person whose house it was, lets me stop by, and she gives me milk and cookies sometimes, and we talk. She's a friend of mine. And I've always, this isn't quite the language. Her language was a lot more simple. She said, I always admired all of the little knickknacks and things that she had. And I said, gee, my friend Susan would like to see your stuff. And she said to me, well, you just bring your friend Susan by any time. So I did.
So she was very literal. We now have
I'd like to say at that point in time, before you answer this, that charges against her were, the people refused to dismiss. It was taken down from like 87 felonies to 1 misdemeanor for no fine, no time, but they wanted a hammer over her head.
No probation. Okay, we've got a couple calls in here. It's Attorney Steve Fox, Attorney Avrum Harris. Can we help you?
Hey, Steve, it's Deanna.
Yes. Oh, yes. Miss Pujol?
Yes, I told you I was going to call you tonight.
Thank you.
I've actually got a question. It's kind of pre-legal. Somebody broke into my house the other day, and
I'm sorry.
I'm pretty damn sure it's the kid across the street, because she's bragged about doing such things before, and about how she and her buddies always have cash, although none of them work and their parents don't give them money. And she even admitted once to taking something out of my driveway. The question is, how the heck do I nail her to the wall?
Well, I would, you can always put up a camera, so if she eventually does it again, but again, our responsibility is to defend or to sue. The remedy you're asking is, how do you create, how do you verify evidence? other than setting up another situation where I hate to say entrapment, where she might want to steal something and gain evidence against her.
And that could be a dangerous situation.
And I'll tell you something. Someone broke into my house one time and took my son's turntables. He called around. They were specially made turntables. They were pretty unique. He found out who they were. Instead of using self-help, and I had to explain to him we don't do that, I called the sheriff's department. The sheriff's department out here was very good. They went over to the person they suspected, and got a warrant, went in and found the turntables, which the person had sold to somebody else. So sometimes you have to report it to the sheriffs and ask that they gain entry to check to see if your valuables are there.
Okay.
But we do appreciate you calling, and thank you very much.
Bye.
Bye. And the next call, we have a lot of Attorney Steve Fox and Attorney Avrum Harris. Can we help you?
Yeah, hi. I was wondering if Mr. Harris can explain what a cruise waiver is and can justify why they let somebody who's pleading guilty out when they keep somebody who refuses to plead guilty in, when the person who refuses to plead guilty is presumed to be innocent, or at least not guilty.
I don't know if I can justify it. I don't think my duty or obligation is to justify how the system works. I can, however, explain it. And I'm not saying I agree with it. What a cruise waiver is, and that's spelled C-R-U-Z after Cruz versus Superior Court, or maybe it's Superior Court versus Cruz. But in any event, it's a case that established that as one of the terms of a plea bargain, the defendant can be released with a return date and with certain conditions. And it's on the understanding that if he or she does not meet those conditions, which are generally report to probation, don't pick up any new crimes, search and seizure conditions generally apply during that period of time, if that and come back when you're supposed to come back. If that person violates any one of those conditions, then their guilty plea stands. the deal doesn't, and they can get up to the maximum exposure that the crime allows. Generally, I believe, and it's simply opinion, the reason that the district attorney and the court will sometimes agree to it fall into one of two categories. Either the person is not truly a danger to society in the sense of serious or violent crime, and the second one is, I think sometimes they're hoping and betting that the person will not come back or will pick up a new crime, because this way they got the plea. And when the person, let's say the plea was for 90 days in county jail, if the person violates the cruise waiver, when they pick them up and bring them back, they can give them up to the maximum prison sentence.
Just like I thought, it's almost like a spider's web. But
It's a setup.
Right.
The second reason for the cruise waiver, and people always say, are there no short answers in the law? And the answer is yes, there are no short answers in the law. The second reason for a cruise waiver is that frequently there are those who have legitimate personal interests that they have to get in order. They have to make arrangements for the dog or the cat to be put in a kennel, for their businesses to go on, for their house to be closed up, for their mail to be taken care of, things of that nature, things that they cannot take care of while they are in custody. So there is also a legitimate purpose that is served. Now, why keep somebody who has admitted to a crime, why allow that person out while the guilty person, while the person awaiting trial is in jail? It's because even though ostensibly one is innocent until proven guilty, I think that's a level that we strive toward, but it's not a level that in fact is the one that's accepted. And for the purpose of a bail review, a person is presumed to be guilty. The process that the court then goes through is the following thinking. If the person is presumed to be guilty, the first question that has to be answered is, are they a danger to society? Obviously the answer is yes, because they're guilty. That's the presumption. The second question is, what is the likelihood of flight? And to that they look at the nature of community ties. Do you have a business that you would lose, a pension you would lose? How long have you worked at your job? Do you have a number of children who are enrolled in school whose lives would be turned upside down? What about a spouse, the nature of their community involvement? And yes, that is generally a system that favors those who are entrenched in middle-class America or beyond, but that's the way the system works. Does it favor, so are we letting people out who have pled guilty and keeping locked up those who are awaiting trial? Yes. At the same time, a judge has a right to say no to a cruise waiver. Cruise waivers do not go out to those who
Not automatic.
They're not automatic, and even if the DA agrees to it, a judge can say no. They're not going to turn loose on a cruise waiver somebody accused of assault with a deadly weapon or any one of the homicides.
So non-violent crimes that wouldn't cost society a substantial amount of penalty by letting them out is what you're looking
right.
at. And we thank you with that, and we have another call.
Thank you, sir.
Attorney Steve Fox and Attorney Avrum Harris, can we help you?
Yeah, thanks for taking my call. I just had a question. You made a comment, sir, about how the system, whether right or wrong, tends to favor those who are maybe middle class and more entrenched or invested in their community. I guess what I wanted to ask you is that I really want to believe in the system. I teach my children to believe in the system. But what impact do you honestly believe, based on your experience, that money and position really allows people to go free, as opposed to those who don't have money and power and position get charged? And I ask that because I know individuals who I would have assumed would have been charged with different offenses by the district attorney's office, but I believe it's because of political connections or money or whatever that they're able to get free. And do you see this as 10% of the situation, 20% of the situation in life?
Well, I'll let Avrum answer most of it, other than my feeling is that I see people charged pretty equally. It's just the defense is different depending on what you can afford as far as representation. Avrum, why don't you try answering her?
Okay, first of all, I don't believe that I said that the criminal system is different based upon socioeconomic status. What I was referring to, and I'll clarify it if there's a misunderstanding, what I was referring to was in the bail review process, one is, for that evaluation alone, one is presumed to be guilty. Otherwise, it's the only way that makes sense. If everybody in the bail review process was presumed to be not guilty, everybody would be let out on an OR. So you have to start the process by assuming that somebody is guilty and then seeing where it takes you from there, number one. Number two, do I think that there is a different level of justice for those who have money and those who are indigent? No, I do not. I have been an attorney for going on 23 years. I have been in the private sector. I have made federal case law. I have been a prosecutor, and I have been a criminal defense lawyer. And it has been my experience that the vast majority of the time, the system works. Now, it's not perfect, but the system works. Now, do those with money who can hire any attorney they want get better representation than those who are appointed counsel? Obviously, I'm biased. I'm appointed counsel. Okay? I will tell you, however, that it is my belief and my experience that some of the best attorneys I have seen, in criminal defense lawyers that I have seen in my entire life, work for the Office of the Public Defender or for the Office of the Alternate Public Defender. We are in court 5 days a week. We handle more criminal cases. Our life and our business and our income is not blown out by going to trial, so we don't try and settle a case just because, and I'm not talking about Steve, but there are lawyers out there who do. There are lawyers who try and settle cases simply because going to trial interferes with their income and their life. So I think that indigent people get incredible representation.
I think it's a mixed bag. I think obviously there's, and again, I'm obviously a private attorney, and I think that I only get clients if I'm successful, so I have that incentive. And I think I do better than most in certain public defenders. But I have to say, in Avrum's case, in my opinion, the exception, both in the public sector and the private sector, that if someone was indigent and had Avrum, they do much better than if they had a lot of money.
Well, see, I wanted to say that because he seems to be the kind of human being who I believe he would give his 100% and his all to his client regardless of his socioeconomic status. But I have to say, Mr. Fox, that I do agree with you. I think it's a mixed bag. And I guess I was asking you a question. I was going to hang up and get the answer off the air. I don't understand, in the federal case, we had a vice principal here who faced 45 years and 4 felonies dealing with child pornography on the internet. And I don't know, Mr. Fox, if you remember that case, it's very recent. It involves one of our school districts. My question is, the U.S. Attorney's Office allowed him to plead guilty to 1 felony. Was that basically the fact that they had made the case they wanted to make, they didn't want to overdo it, and he would be out of the classroom and away from children? So what the heck, don't go for 4 felonies, just accept 1? And I'll take the answer off the air.
I'll give you the answer right now.
Oh, okay.
The answer is that I don't think either Steve or I can tell you what was in the mind of the U.S. Attorney's Office at the time that they made that plea bargain. But as I stated earlier, approximately 95% of all cases are resolved by either a plea bargain or the case being dismissed. Only 5% go to trial, and that's because any trial attorney worth his salt can tell you that any case can be won and any case can be lost, and I presume that the district attorney's office felt that a conviction was better than a gamble.
Okay,
now, there is one other thing in answer to your question. Where indigent clients do not get the same level of representation as those who have beaucoup bucks to spend is when we want experts appointed, we have to go petition the court and in a closed hearing called an ex parte hearing, explain to the court why we think it's necessary to spend the money.
Okay.
And the court can say no. And even when they say yes, we can't go get the best person that money can buy and import them from Philadelphia or Baltimore or whatever. There is a court-approved list of those who are willing to work for county scale or state scale. I'm not saying these are bad people. Some of them are some of the finest medical people or scientists that I've seen, but we are precluded unless we can show exceptional circumstances from going outside the list.
Well, thank you both very much.
You're welcome. Have a nice night. And again, this is, you can call in at 726-0382, You and the Law. And we have alternate public defender and excellent attorney Avrum Harris on with us tonight. And Avrum, we have a little time. Do you have time for one more of your war stories?
Yes.
Go ahead.
And the reason that I can tell this one, even though it would appear to violate attorney-client privilege is because the client accused me of malpractice and there was a hearing on it. And when the client accuses you of malpractice, obviously he can't just make the allegation and
Sure.
you can't defend yourself. If he makes the allegation of malpractice, you can violate attorney-client privilege. It's not a violation.
It's not a violation.
Not a
where
violation.
The client has put it into issue, and therefore you're allowed to deal with it.
I had a client who shot at somebody, missed, and hit 2 other people. Obviously, he was in custody when I met him.
Transferred intent.
Right.
Go on.
And he was being charged with attempted murder of the first person and with 2 counts of assault with a deadly weapon with the intent to commit great bodily injury, with great bodily injury. His exposure was something like life plus 58 years. When I walked in to see this young man, and he was young, I recall him being under 25, he was angry, and the anger was being directed at me. Why couldn't he get out? Why was he being locked up? He didn't do nothing, blah, 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 blah. And one of the ways that you learn to deal with this is you explain what they are charging you with, they being those with the power, what they are charging you with, and I read him the charges, and he got very angry at me. How stupid could I be? He missed the guy that he shot at, and the other 2 were an accident. So how could he be locked up? And I explained to him, in this country, we punish people for trying. And he didn't think it was right, and then somebody was going to procure for him witnesses. Ultimately, he pled to, I believe it was 26 years at 85%. It was a plea bargain. And then he said that I had committed malpractice by not putting on his witnesses, who hadn't appeared till after the preliminary hearing. When he walked back into lockup, they said to him, "Are you Mr. So-and-so?" And he said, "Yes." And they said, "Well, we're your witnesses and we're here now. What do you want us to say?" And this is what he said to me. They wanted to know what did he want them to say, and he didn't know what they should say, so I needed to talk to them.
But you don't tell people what to say. You just
Not only don't I tell them what to say when it's the truth, I certainly don't tell them what to say when it's a lie. And when I interviewed them, I said, "Okay, what did you see?" And they said, "Just tell us what to say." And I said, "I want you to say what you saw." And one of them said, "I won't know what I saw till you tell me." And I said, "Okay, this is going nowhere. Interview's over."
Well, you're our example of the honest attorney, and that's why,
Most attorneys are honest attorneys.
and I would agree with that. And thank you for correcting me on that, because I agree with that.
And most cops are honest, hardworking cops.
And that's true too, and it's a shame that sometimes the exception makes us all look bad.
Yes.
You mentioned 85%. I think the audience might want to understand that sometimes, and the way they keep control of somebody who's incarcerated or in jail is they say you can get some time off for good behavior.
Yes.
And some felonies you get 50% off and of your time, and some you get 15%. You serve 85%.
Correct.
You want to explain the difference between that?
It depends on how the legislature and its omnipotent wisdom has classified the crimes. Since we passed term limits and lawyers aren't in the legislature in the abundance that they were, for some reason these people don't know how to write laws, and it's very confusing. But what they have attempted to do is put different crimes in different categories. If you use a firearm, for example, you do 85% of your time. If it's a drug case, you do 50% of your time, and that's only on a state commitment. Once you get sent to state prison and you get assigned a job and you start to do it. The time that you were in county, you get 3/4 time, and this doesn't include 3 strikers who on the first commitment get whatever it carries, on the second one get twice the term and 80%. We literally have to take classes in new math in order to be able to figure out sentencing in actual time. There are seminars given to attorneys to be able to figure this out.
Which is important in the negotiation.
Yes.
And with that, unfortunately, our time is up. I want you to know this has been the most, I think, interesting show on the criminal area, and I would say dynamic, to be perfectly honest with you. Avrum, thank you for being on the show.
Thank you for having me.
And thank you all for watching. Again, every Thursday night from 7 to 8, and you can call in on You and the Law at 726-0382. Thank you very much.
Thank you.
Thank you, Avrum.